Hello everyone, a very good evening. Welcome to the CAIIB Foundation June 2025 batch for the BRBL paper. Here we are covering all the units module wise. So today we'll be discussing the unit 34, which is the last unit of module D as well as the whole syllabus. So this is the Prevention of Corruption Act 1988. This is the last unit. With this, we'll be finished with the whole syllabus. If you haven't yet watched these videos, do watch them. These are very important for your exams. This will give you an idea about all the topics that are important, right? And give a kickstart to your preparation. So let us start by understanding the Prevention of Corruption Act of 1988. So this act, which is also in short known as the PC Act, was promulgated on 9th September 1988 and as the name suggests, mainly to consolidate and amend the law relating to the prevention of corruption, right? So because of the huge or high prevalence of corruption in our nation, this act was it came into force and all the previous acts or the laws they were now consolidated. So this is the main statute aiming to curb corruption among the public servants and others in the country. And it was amended in 2013, 2018, and more recently on 3rd of September 2021. We'll be seeing these important amendments. And if we talk about the investing agencies, so the Government of India, Ministry of Personnel, Public Grievances and Pensions has introduced the standard operating procedures under Section 17A for investigating agencies. So this is important. Standard operating procedures which has been established by the Ministry of Personnel, Public Grievances and Pensions. Again, if we come back to this act, it deals with how the public servants, if they're engaged in corruption, taking bribes, giving bribes, or any unlawful activity or behavior, how the act is going to deal those cases. So there are certain terms appearing in the act like election, which means election which is held under any law for the purpose of selecting members of the parliament or legislature or local authority. Then public duty means a duty in the discharge of which a state, the public, or the community at large has an interest. Then the meaning of public servant, any person in the service or pay of the government or the local authority or any corporation established under a central, provincial, or state act. So, any person who is authorized to perform any duty in connection with the administration of the state or justice as decided. These are the public servants which are covered under the act. And there's also a term which is undue advantage, which means any gratification other than the legal remuneration. If the public servant seeks a gratification other than the legal remuneration for their duties, then it will be known as the undue advantage. Right. Then, under the Act, we have the section 3, which gives powers to the central and the state governments to appoint special judges. These special judges will try the cases under the act. Also, the offenses are specified which may be dealt with by these special judges and the minimum qualifications which are necessary for their appointment. So, special judges are appointed by the central and the state governments to try the cases of undue advantage or corruption as stated under the Act and the offences which may be dealt by these special judges as well as their minimum qualification. All are given in section 3, right? So it will cover all the offences which are punishable under this act or any conspiracy to commit or any attempt to commit any abatement of any of the offences specified, right? Then the cases that may be tried which are contained in the code of criminal procedure or any other law will be tried by the special judges only in the particular area within which it was committed or appointed, right? And there's also the provision of transfer of suits. Another important point is that a situation sometimes arises when one party in the trial requires to be transferred to another court in the same or another city or to the high court. This is known as the transfer. So the question here is a general one since it is pertinent to all the cases presided over by a special judge. So cases can also be transferred. So this question was actually dealt with concisely by a High Court of Judicature Madras in the case of M. Gopal Krishnan versus the Inspector of Police in 2009, which arose since none of the provisions in the Prevention of Corruption Act deals with the transfer of cases. Other judges were also there, which or other cases were there, which gave the same solution. Thus, it became well established that only the transfer of case from a special judge to the High Court itself was prohibited and not the transfer of a case from one special judge to another special judge. All right, so this was the decision given under the many cases related to the transfer. Then, in this given table, we have been given the different offenses and the penalties. So, this is given in the section 7 to section 15 of the Act. All the offenses falling under the provisions of Prevention of Corruption Act and the punishment or fine prescribed. So, we have a summary. Section 7, where the public servant is bribed. So, punishable with imprisonment for a term which shall not be less than 3 years and it can be extended to 7 years. Also, he shall be liable to fine. Then 7A, taking undue advantage to influence public servant by corrupt or illegal means. So, if any person tries to take undue advantage to influence the public servant, then punishable with imprisonment for a term which shall not be less than 3 years and can be extended to 7 years. So, in many cases, we will see the offenses, they have the same punishment. Three here and another one here. Right? So, section 7, 7A, and section 10 deals with the same punishment. When the public servant is bribed, taking undue advantage to influence public servant, and when the person in charge of the commercial organization is found to be guilty of the offense of corruption, and the punishment for abatement of offenses. So, section 12 as well. So, 7, 7A, 10, and 12 have the same punishment. Then, where the person gives or promises to give an undue advantage to another person, then imprisonment for a term which may extend to 7 years with fine or both. Offense relating to bribing a public servant by a commercial organization, then punishable with fine. And public servant taking undue advantage without consideration from a person, punishable with imprisonment for a term not less than 6 months and it can be extended to 5 years, also liable to a fine. So these offenses and the punishment prescribed are very important. All right. Then we have the definition of the criminal misconduct, which is given in section 13. A public servant is said to commit the offense of a criminal misconduct if he dishonestly or fraudulently, if they dishonestly or fraudulently misappropriates or converts his own use property, any property entrusted to him, or any property under his control as a public servant, allows any other person to do so. So, if any property, let's say a car, is given to them by the government, but they're using it for their personal use, that then it is a criminal misconduct. If he intentionally enriches himself illicitly during the period of his office. So these will be termed as what? These will be termed as criminal misconduct. Also, the section 14 deals with the punishment for a habitual officer who is who was convicted initially for this offense and then who subsequently commits another similar offense. Such person will be punishable with imprisonment for a term which shall not be less than 5 years and it can be extended to 10 years. All right. And again, if someone tries to attempt a offense, then punishment will not be less than 2 years and it can be extended to 5 years with fine. So whenever we are using this term with fine, how can we calculate the fine? How can we calculate the fine? So the provision is given that the criteria to be taken into consideration by the court when determining the amount of fine is brought out. So, fixing the fine, the court shall take into consideration the amount or value of the property which the accused person has obtained by committing any offense, the pecuniary resources or property referred to in the clause. All right, these will be included. Then, who are the persons authorized to authenticate is also given in the act, the cases, and we also have the powers to inspect the banker's book. So, persons so authorized are no police officer below the rank. In the case of Delhi Special Police Establishment, then an inspector of police. In the metropolitan areas of Bombay, Calcutta, Madras, and Ahmedabad, and in any other metropolitan area, then the position of an assistant commissioner of police, and elsewhere not below a deputy superintendent of police. Then we also have the section 18 of the act, which gives powers to a police officer who has the reason to suspect that for the purpose of investigation or inquiry it is necessary to inspect any banker's books, right? So he may inspect any banker's book if they are related to the accounts of the person suspected to have committed that offense, or they are suspected to be holding money on behalf of such person. So if the public officer is having an account, that bankers books can be checked. Also, if they have, let's say, transferred the black money or the corruption or the bribe amount to their relatives account, that can also be inspected. So the bank so approached has to provide the certified copy. So we had studied about this in the bankers books evidence act, that now original documents are not required. The banks can simply provide the certified copies of the relevant entries to assess the public officer. However, again, this police officer should not be below the rank of a superintendent of police unless he is specially authorized in this behalf by a police officer or above the rank of a superintendent of police. So if they're above the rank or they are authorized by any officer, then they can. Otherwise, below this rank, the police officer cannot investigate. All right. And that is all. We have covered all the important provisions of this act. There's also the appeal and revision, which is allowed. And the higher appeal normally lies with the High Court. So with this, we have completed and finished the whole syllabus of our BRBL paper. All the units are available on the YouTube channel. So make sure that you watch them. Make sure that you download these PDFs. These are very important. And if you want to study all of these chapters, these units in detail, the whole syllabus, then join us in the CAIIB Super Elite all-in-one plan. So here you'll get the live classes, mock tests, and the notes, right? And if you want to join today, then you can have the benefit of using the code SHIV and avail 52% off on your subscription. The Shivratri success sale ends tonight, so join the course now, avail the benefits, and start with your preparation. You can download the PDF from the link that is given in the description box. Any doubts, any queries, let me know in the comment section. Also, do like, share, and subscribe to the channel of Oliveboard. Thank you so much, and all the best.